Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. We are thrilled to be commemorating the 200th anniversary of the Supreme Court of North Carolina right here in historic Rowan County, and we have been wonderfully hosted and so much appreciate everybody for their graciousness and wonderful spirit in making sure that we have had a really fantastic time here. I'm Sherry Beasley, I'm the Chief Justice. To my right is Paul Newby. To my left is Robin Hudson. To Justice Newby's right is Justice Irvin. To Justice Hudson's left is Justice Morgan. And to Justice Irvin's right is Justice Anita Earls. The court calls Hamlet HMA LLC versus Hernandez.
Good morning. Thank you, Your Honors. May it please the court, my name is Will Freeman. I'm here on behalf of the appellant, Sandhills Regional Medical Center. Before we start, I would like to take 1 minute and compliment opposing counsel, both here and at trial, and the court and the clerk and all the staff at all the levels who have shown that you can follow the rules and be zealous, very zealous, advocates for your client, but still be courteous. It's just been professionalism at every level, and it's worth noting today that's the case here, and thank you. Turning to my argument, though, this case is about whether Dr. Hernandez's claim against my client, the hospital, under the Unfair and Deceptive Trade Practices statute can stand. And the statute in question in its current form was enacted in 1977. And in enacting the statute, the legislature specifically excluded from its reach claims for, quote, professional services rendered by a member of a learned profession. And as this court said in Sykes this summer, and other courts have said before, the legislature really is establishing a two-part inquiry here as to whether the learned profession exception, sometimes called the learned profession exemption, applies such that a claim by Dr. Hernandez or anyone can be maintained under the Unfair and Deceptive Trade Practices statute. So quoting from the Sykes test, first, quote, first, the person or entity performing the alleged act must be a member of a learned profession. And I don't think there's much dispute in this case that my client as a hospital satisfies that first Sykes inquiry. The second prong or inquiry that Sykes set out for us was, quote, second, comma, the conduct in question must be a rendering of professional services. And I think that's the inquiry and the prong where the Court of Appeals, the trial court, everyone has wrestled in this case. So that's where I'd like to focus my argument. Do the activities here in question constitute the rendering of professional services for a hospital? And I think of this sort of in 5 spheres. And Your Honor, I apologize. I'm nervous, and I forgot to reserve any time for rebuttal. If I could, at this point, a little bit late, reserve maybe
Let's go ahead, right ahead.
10 minutes. Thank you very much. The sort of 5 spheres where I think it's important to talk about that second Sykes inquiry are the starting point from Sykes and the case law is that this is a broad exception. Quote, exception for medical professionals has been broadly interpreted. And the second sort of lens that we look at this issue through is the language that the courts use when they're analyzing situations. In the Burgess case, favorably cited by this court a few months ago, does a matter affect health care? In the Wheelis case, also favorably cited by this court in Sykes a few months ago, does it regard, quote, ensuring the provision of adequate medical care? Cameron, does it regard assurance of good health? The Zaldivar case of the Court of Appeals, does it place a limitation on a defendant's ability to provide medical care? And then in Sykes, the court looked at whether the actions were, quote, sufficiently related to patient care. So we have this broad standard, this broad language being used by the court. The third sphere that I think illuminates how the court can look at whether or not this second test is satisfied is the legislature and what it knew and its actions and what has happened. And as noted in the state of North Carolina's amicus brief, the previous incarnation of the Unfair and Deceptive Trade Practices statute was amended in response to this court's finding in the J.C. Penney case that debt collection activities were not within that statute. And the J.C. Penney case came from common law. And the legislature wanted to overturn that opinion, but did not want to overturn it for learned professions. And it specifically carved out this exemption for them. And so, and no amendment has occurred since 1977, even though it's been decades now of case law, at the appellate level, certainly. In 1970,
so let's just kind of put it in the big picture. So your client recruited the defendant to come to provide surgical services. Part of the agreement, 36 months. He only worked for just over 18 months. They had this disagreement. In the midst of the trial, it seems like the plaintiff had a fraud claim, but then also an unfair and deceptive trade practice claim, somewhat related to, well, you kind of got me up here under false pretenses, and even if I had signed the contract that I was asked to sign after 18 months, that it was somewhat illusory because there was a you could have fired me for no reason clause in there. And it seemed to me the trial court really wrestled with, okay, I'm going to let the fraud claim go forward. I don't want us to get off the main issue in front of the jury with regard to, was Dr. Hernandez competent or not? Are we going to get into, well, his failure to attract patients was really his fault, not so much the area, if you will. Can you comment about, I guess, the fairness of the fraud claim being presented to the jury, even though not in the context of an unfair and deceptive trade practice claim?
Yes, Your Honor. And if I can just back up just a little bit to answer your question a little more deeply than that. I'm the plaintiff. I actually brought suit. These are counterclaims by Dr. Hernandez against me.
Right.
Well, the hospital. I apologize.
No, that's good.
And this is something that is difficult to discern from the record, but I think I tried to lay it out in the brief. Is the case sort of focused initially on this? You lured me to an area where I could not thrive, and we were going to say the reason you didn't thrive was because of these medical issues, and you correctly, Your Honor, just said the court didn't want to be having all this evidence in the juries about, in front of the jury about the physician's skills. And because of the court's sort of prodding, the case sort of focused a little bit to the need in the community, and that's why we had 3 physicians called near the end of the trial, Dr. Nascimento, Dr. Dia, and Dr. Mangum Smith, about whether or not the community could support a surgeon. But then the case kind of shifted a third time, and the court really wanted us to focus on the idea of, you brought me here and knowing halfway through the 36-month period, you would give me this contract that had a termination without cause provision. And that was the badness, the wrongful act. And that's sort of where the court ended up its focus. And I know that's not exactly the question you asked, Your Honor. I'm not trying to avoid it. And so as presented to the jury, those were sort of the emphasized facts of the trial. The others were still there. They'd heard testimony on them, but the court really was pushing us hard to get away from these physician issues and focus more on those. And in fact, after the directed verdict was granted in my favor on the UDTP claim, the court, just a page or two later in the transcript, says something like, let's not talk about the need, let's not talk about the sort of bringing him down here under false pretenses, let's focus more on this contract, this luring, this 30-day secret issue. So I think your question is, let's discuss how the fraud claim got sort of tied in with those two claims. And I'm not sure exactly how to answer it. I guess one of the issues, the themes, and this is in the amicus brief of the North Carolina advocates, is, we got to give this guy his day in court. Well, he had his day in court on the fraud claim, and he raised lots of defenses that were rejected by the jury to the plaintiff's breach of contract claim. And they are different claims. They are different actions. But if the jury had returned a verdict on both fraud and the unfair deceptive trade practices statute, I think I would have moved for an election of remedies. But it didn't happen because we won the fraud claim and the unfair deceptive trade practices had been, a directed verdict had been granted. And I think that answers your question, but I'm not.
Well, one question I had mulled over, and I don't claim to be an expert in this area of the law at all, but I went back and looked at the complaint, and the factual allegations in the complaint on the fraud claim and the unfair and deceptive trade practices claim are virtually identical. What should we make of that fact, if anything, coupled with the fact that the jury rejected it?
I think it gives us some confidence in upholding the trial court's determination, because the sort of arguments he made got presented to a jury. He had his day in court, and the hospital prevailed. And so we don't have to feel like we've silenced a person from making an argument. And also, if I can, Your Honor, I'm sorry, I see a look on your face. I don't mean
I make faces when I think or at least when I attempt to think.
And I had actually made a motion and said, you can't raise all these issues you're making, and the trial counsel tried to amend the complaint, and the judge said, we're not going to do that on day 8 of a trial, but I am going to let them make some of these arguments. We're going to, between the pretrial order and the complaint, I think there's enough here about these 30-day provisions in a recruitment and an employment contract.
But just following up for a moment on this issue of the difference between a fraud claim and an unfair and deceptive trade practices claim, certainly the elements of the claims are different.
Absolutely.
And isn't part of the reason why the legislature thought it was necessary to have an unfair and deceptive trade practices claim and created the avenue was because the common law fraud claims were not solving the problem of deceptive practices in commerce?
I think that we can agree that is probably a factor in the legislature's mind. We don't have a true, legislative history and record, but certainly that point is made in the amicus brief. They are different claims. They do have different elements, and they've different. I'm sorry.
No, please finish your answer.
I think I largely agree with you. I just sort of think in your gut when you're like, gosh, I hate to deny a guy his day in court. Well, he got his day in court. That's sort of my point. I know it's not quite the answer, though.
Well, I do think he didn't get his day in court on the claim that the legislature put in place because fraud claims were not working in these contexts. But let me go back to your initial point about how broadly the learned profession exception should be read. And I just want to understand, do you agree with the amicus brief that was filed by the Hospitals Association that there are some activities of a hospital that would not be covered by the learned profession exemption? Or is it your view that whatever a hospital does, it's related to patient care and therefore it's covered?
Let me back up just a little bit. I think that this court has said there are 2 tests. You've got to be a member and you've got to be rendering professional services. So there would be circumstances where a hospital would be doing an activity that isn't the rendering of professional services. Does that answer your question?
Yes.
Okay.
And then just let me follow up to that. Does the rendering of professional services have to be done by a professional? In other words, I believe that there was no evidence in the record that Jim Whitaker and Mike McNair, who were negotiating this contract with the doctor, that there's no evidence that either one of them were doctors.
Well, if I could say the short answer is non-MDs can render professional services, and entities can render professional services. And I think that's the first Sykes inquiry is this thing, and the court used the language person or entity, a member of a learned profession. And so the first test is it a member of a learned profession? A hospital, that's my client. The Shelton case said hospitals are a member of learned professions. This court has favorably cited that the Sykes case was a intermediary in-network chiropractic company, and it was protected by the UDTP. In the Cameron case, it was a hospital. In the Wheelis case, it was a hospital. And so a hospital acts, it's a thing, it's a company. It's not a person. It acts through agents. And so there's never been a sort of third prong is, are you a member of a learned profession? And is everyone within you a member of a third learned profession? And was it the rendering? I think to sort of say it has to be a hospital and everyone involved has to be a physician or an attorney or a member of the clergy, that's a little bit more, I think, than the case law supports. I think it's more, this is the CEO of a hospital doing what a hospital does, which is recruiting physicians into the area.
But in the fact pattern that we have here, how is it that the learned profession exception would apply in this employment contract context? It appears as though, on the surface at least, it happens to be an employment contract that just happens to be between two parties who are members of the learned profession, hospital and doctor. So does that inherently mean that because it was an employment contract, that because each party belonged to a recognized learned profession, that inherently and automatically makes it a learned profession exception situation?
Your Honor, I think you're saying because both parties were members of learned professions, is it just automatically apply? I don't think so. Does that answer your question?
Oh.
But then, I'm sorry.
Well, yes, it does answer it, but I'm wondering, are you going far enough with talking about the breadth of the exception to say then that because both parties belong to the learned profession, then the exception is automatically going to apply, despite the fact that overwhelmingly the basics of this contract smacks of employment?
If I can give you a little bit of a long answer, Your Honor, I think when we sort of lay the facts of this case onto the law, which is the broad interpretation, my client is a rural hospital, and there was testimony in the record that the mission of my client was to recruit physicians into the community, not just surgeons, but any physician. And the mission was to provide quality health care for the community, for Hamlet, North Carolina. And this was really important in Hamlet because almost 80% of the people were on Medicare or Medicaid. And Mr. McNair, the CEO at the time who recruited Dr. Hernandez, Mr. McNair testified, patients can't afford to travel. They don't like to travel. And he said, I felt it was my obligation to have a surgeon here. And as part of my mission, Mr. McNair says, part of my mission to have a surgeon in a community, I surveyed the community. I looked at demographic data and zip code data. We had annual surveys of what physicians were needed. I spoke with other physicians. I noted people were having to leave the community. I looked at the historical need for surgeons, and Mr. McNair and Mr. Clay, the current CEO at the time of the trial, both said in their decades of healthcare, this community needed a surgeon. And that's not just the mission of the hospital, it's also a mandate.
I get that.
Okay, Your Honor, I'm sorry.
And that's laudable, obviously. But in terms of talking about the learned profession exception, since this was an employment contract, an employment opportunity for the doctor to come, and it was an opportunity for the hospital to provide someone who was going to be stable and available for the community, how is it that the learned profession exception applies in terms of the rendering of professional services, which is ultimately what we've got to answer? If this was an employment contract that happened to involve medical providers and does not therefore exclude this professional exception to apply?
Your Honor, I think that a hospital, that's what a hospital does. It renders services by having a physician there at 3 a.m. when your appendix ruptures and you need someone there who's a surgeon, that's what a hospital does. Is it has a surgeon there who lives nearby. That's how it operates. That's what a rural hospital does. That's its rendering of profession. That's one of the core sort of things a hospital does, is have a doctor there when you need it. And so not to say that the mechanism by which it satisfied that mission wasn't a contract and an employment contract. I agree with you there, Your Honor, absolutely. But in this case for a physician, the rendering of services by a hospital is getting a doctor there. And that's from the mission of the hospital and also from the statutes and regulations and case law of this court.
Hypotheticals can be dangerous, but let me attempt one to try to talk about where I'm trying to go with you so I can have what I need. If a plumber had come to the hospital to fix some deficiency in the water system, the hospital is there obviously needing water to do some of what it needs to do. Let's say that the plumber was defective or deficient in terms of what he or she happened to render. Is there a learned profession exception because the hospital is involved in rendering professional services, and therefore, if something's going on with a counterclaim from the plumber, that the hospital can say learned profession exception, even though this is something that is more in line with services rendered as opposed to professional services from a hospital medically?
And I think Your Honor said it at the end, it's important that there has to be a counterclaim from the plumber back against the hospital.
I was trying to make it relevant
No,
to what
I
we got
understand
here.
totally. And so depending on the nature of the counterclaim, it could be, but it's difficult for me to think of a scenario where that would be true. And if I can, I think Your Honor is mostly correct, is what I'm saying. But I suppose we could think of some wild set of facts where it relates to professional services. But that's where the Wheelis case really kind of helps, I think, understand this, is because in that case, and the court opinion says, a whistleblower, anonymous whistleblower for malicious purposes to hurt a physician, went and broke a law, criminally accessed records, sent them to the board, and then when the hospital is sued for that anonymous whistleblower's criminal action to hurt the physician, the court in Wheelis, and that's an appellate court decision, said, hey, narrowly, this is about a crime, and this is about a malicious activity just solely designed to hurt a physician. But if you step back and take the broad view, then it's about health care. It's about, and it was sent to the medical board. Maybe it was sent for a horrible purpose and an illegal purpose, but it's about medical care. And that's what we have here, is we have we need a doctor we need a surgeon in the community, and we went out and got one. The specifics of the contract and whether or not we should have told the doctor about the 30-day, that there was going to be a 30-day provision, whether or not he knew subjectively whether there was one based on his history. That's sort of the minutia, and always a careful drafting counterclaim or claimant is always going to carefully draft it so narrowly, and the court says, no. We're talking about a hospital having a surgeon in the community, and that's what the trial court ultimately came to, and the dissent in the Court of Appeals said, hey, you're being sued by Dr. Hernandez for getting him here. You're being sued for 17 days of being on call. You're being sued for all these issues about staffing, I think is the term used, staffing a hospital. And that's what this case is about. And it's important to take that broad view and look back and say, yeah, this is about a doctor being here.
Mr. Freeman, I just wanted to let you know you're into your rebuttal time.
If I could just
Sure.
say a few more
It's your
minutes, Your
time.
Honor. I think there's sort of this focus on this business deal. This was a terrible business deal for the hospital. Dr. Hernandez got more than $900,000, and he could refer patients to any hospital, even a competitor. Dr. Hernandez had the contractual right to be on staff at a competitor's hospital if he wanted to. He was going to get $900,000 more than, no matter what, right? We just wanted him here in the community, and that's why the contract ties him not to the hospital, but to the community. It says, we're going to give you more than $900,000, and all you got to do to get it forgiven is stay here, be here, open a practice full-time, don't turn anybody away if they're on Medicare or Medicaid, don't discriminate, and keep privileges, take some call at our hospital, take some unassigned patients, and we will not make you repay that $900,000. And when remember there was a 36-month period, when the halfway point had gotten, we gave him another contract that he had a choice. He could get $325,000 a year annually for the next 18 months. We might have terminated it, but we might not. We'll never know because he didn't accept it. But regardless, we also gave him an independent contractor agreement that was going to give him a cushion of $200,000.
Is there ever a set of circumstances under which the extent to which a contractual arrangement did or did not involve the rendering of professional service would involve a question of fact?
As I read the case law, there's been 10 opinions.
And I've read all of them this morning.
There's been 10 opinions that are published by the state court, appellate courts, that involve the rendering of professional services, and none of them went to the jury. They were all decided on a summary judgment, motion to dismiss, or directed verdict.
Do you infer from that fact, the fact that none of them came up in a context other than that, to mean that there can never be a question of fact that would govern whether the learned profession exception applies?
I think you sort of fall back on the standard, which is the trial court's directed verdict standard, right? They've got to take all the...
I understand that's what we've got here, but I mean, the real issue that we've got before us is was the trial court correct in directing a verdict in your favor with respect to the Unfair and Deceptive Trade Practices Act claim on the basis of the learned profession exception?
I think the trial court had the right to be the gatekeeper on that claim, but I don't know that that's directly answering your question, because it's almost, it's not like a Fry analysis, but it's almost like the trial court can survey this and say, I see here learned profession issues, and therefore I'm not going to let this go to the jury. And that's how, 9 opinions have not allowed to go to the jury. Only 1 has thought that it should have gone to the jury, which is the Court of Appeals majority in this case. If I can just briefly, Your Honors, I'd ask that the trial court's decision be reinstated and that the Court of Appeals majority opinion be overturned. And I'd like to reserve the balance of my time for rebuttal unless there are any more questions at this point.
Thank you, Mr. Freeman.
Thank you very much, Your Honor.
May it please the court. My name is Mark Hayes, and I represent the appellee, Dr. Hernandez. Professional services rendered. Those words are the polar star of this case because they are the words from the learned professional exception itself. Professional services rendered. Each one of those words means something. Don't let Hamlet distract you from those 3 words. And its very first distraction is going to be about this altruistic mission, about how it was a small town hospital and et cetera, et cetera. Well, that's a distraction, and it's also, procedurally speaking, untrue in this case, because we're at a motion for directed verdict. This is just like for a motion to dismiss. Every fact, every inference is drawn in favor of Dr. Hernandez, not in favor of Hamlet. So when Mr. Freeman talks about, well, there was testimony about this and there was testimony about that, they don't get that benefit. They also don't get the benefit of just kind of cobbling policy ideas from the air about, how they're doing great things and hospitals are doing great things. They don't get that benefit. We're here at a motion for directed verdict. If this was an old Western, I'd put a white hat on my head and I'd put a black hat on Mr. Freeman's, and knowing Mr. Freeman would probably wear.
And you both look really good. Huh?
Absolutely. Hamlet is not here to argue that it did nothing wrong. Hamlet is here to argue that it did something wrong, but it should get away with it. That's their argument. And get away with what? Well, Dr. Hernandez was making $325,000 in Maine as a successful surgeon. He saw an ad about coming down to practice in North Carolina. He responded to it. Hamlet said, set up this independent practice. Well, Dr. Hernandez didn't want to do that. He thought it was just going to be regular employment. He didn't want to take that risk on. Hamlet said, well, we got these studies that'll show this practice is going to be successful. You know, we'll have the patient need for you. It'll work. But that wasn't true. Those studies didn't exist, and that's coming straight from the complaint, which, again, we're assuming is absolutely true. The CEO, Mr. McNair, he's actually said in the testimony, and this is on page 889 of the transcript, he knew that the practice would be a financial failure. He said every practice that sets up down there is a financial failure. So Dr. Hernandez still wasn't convinced. He still thought, well, this is too risky. So he said, well, how about an employment option? You're asking me to have this 3-year commitment where I have to practice down there. How about if the independent practice doesn't go well? You let me come on as an employee making what I made in Maine, and you give me a contract with a term that finishes that 3-year commitment. Well, Hamlet says, all right, we agree. But the CEO knew, and this is on page 449 and 860 and 861 of the transcript, he knew they would not offer an 18-month contract with that term. He knew that they would offer a 30-day only contract where they can terminate him for any reason. And he also knew there would be a no-compete clause, which would put Dr. Hernandez in a complete catch-22.
Now, as I read your colleague's brief, at least, he indicates that the non-compete provision only applied did not apply in the event that there was a not-for-cause termination. Is that right?
In the event that there was a what kind of termination?
That there was a termination, but it was not for cause. It was just a causeless determination, and that's my word and not anybody else's.
Right. I think the inferences, again, the procedural posture here is so important. The inferences are what's actually going to happen. Because what happened, you know, you don't know how the facts are going to work out and how things are going to be exercised.
Which is one of the reasons I asked the question of your colleague about whether there was a possibility of a question of fact here, and I was going to ask the same one of you, so you can have that while you're at it.
Right. There absolutely is, and I'll get to that when I'm talking about the plain text more thoroughly, but there absolutely is. So Hamlet put him in this catch-22 one way or the other. There's a discussion when Dr. Hernandez says, I want this contract, they say no. Dr. Hernandez says, well, I'll even work for almost $100,000 less if you'll just give me the term. They say no, we still want to keep this termination clause in there. Which, I mean, the only inference from that is going to be that they are going to exercise it. So the idea that Dr. Hernandez walked away from the table is kind of crazy. Anyway, so Hamlet, again, basically gets all the upside of they're going to make the money from the facility fees, the hospital stays, you know, being able to pay their nurses to do things, but none of the downside of the losses that are going to happen with this practice that they know, again, by their CEO's own words, is going to fail. So the bottom line is we have deceit in contracting and advertising for the purpose of making money. And the question for this court is this a sort of claim for which the legislature intended it to go unchecked by the Unfair and Deceptive Trade Practice Act?
Let me ask you one further question, just because, I mean, your colleague got up, as you've already pointed out, and said that we were this altruistic, eleemosynary institution that was out there trying to do good for the community in Richmond County. Your argument is, no, they were out to line their own pockets at the expense of Dr. Hernandez. I mean, does this all come down to how one ultimately determines this contractual arrangement ought to be characterized?
I think it ultimately comes down to the deceit in how this agreement was.
But see, he says there's no deceit. You say there's deceit. Do we have to find in your favor on the facts? One of the problems I'm having with this case is it looks to me like one side characterizes this agreement as one thing, and I won't use my own characterizations, and one party says the other, and both of you are acting, at least if I'm understanding your arguments correctly, maybe I'm not, in which case you tell me, but both of you seem to be saying it ought to be characterized either the way you're characterizing it or the way that Mr. Freeman is characterizing it. So does this come down to a question of characterization?
Well, we don't have to make that determination because remember the hats we're wearing. We're at a motion for directed verdict. I've got the white hat on. Everything in the complaint is in our favor. So if there's a characterization to be drawn, it's in favor of Dr. Hernandez.
As the answer to my question, it comes down to a characterization. There's evidence to support my characterization, and therefore I win?
I don't think so, Your Honor, because at a motion for directed verdict, we're not dealing with the substantive evidence of the claim. We're assuming it's true. Now, whether your inquiry is...
That's my ultimate problem, is that both of you seem to be arguing, in effect, that we have to resolve the merits in order to determine whether the learned profession exception applies.
Right.
That's essentially what I'm hearing both of you say in very different ways.
Right. And if I'm presenting it that way, absolutely I'm not, I don't mean to say that. The only reason I'm presenting these facts is so that this court will have a context for the sort of claim that it's going to let go unchecked. But again, we're supposed to be looking at the complaint as if it's completely true.
But if the rendering of professional services is supposed to be looked at broadly in terms of talking about the learned profession exception, while being at the directed verdict phase of the trial, why would the exception not then be broad enough in this employment contract situation, as your opponent is arguing, that because the hospital is endemically involved in rendering professional services, why would that not capture then the exception automatically?
Your Honor, I think the most direct answer to that is the exception is not to be interpreted broadly. And the state's amicus brief, and I know from my own time clerking with this court that the white-covered amicus brief sometimes gets short shrift, but I really commend to this court the amicus brief of the AG's office. They really delve into the policies, and they talk about how, first of all, there's this general rule in these sorts of statutes that these sorts of exceptions are narrowly considered. It talks about the AG office's own opinion that was issued when the legislature asked for an opinion about how this exception was going to be interpreted right when it was being passed. And the AG's office issued an opinion to the legislature and said very specifically, this is just it's actually said, I believe, is to be strictly drawn was the words that opinion used. When Mr. Freeman talks about it, the legislature meant it to be broadly interpreted. Take a hard look at those parts of the brief. There's no citation to anything about the legislature or to the AG's office. He's citing to Court of Appeals opinions, but nothing about the intent of the legislature.
Let me ask you a question about that. I'm sure that you know, recently in Sykes and in a number of cases from the Court of Appeals, there's language to the effect that the exemption is to be broadly interpreted. Are you asking that we revisit and/or limit our holding in Sykes, or overturn it, or distinguish it somehow?
I would read Sykes as observing what has happened in the Court of Appeals rather than commending that to happen. In Sykes, you had a unique situation where you had an entity that was entirely comprised of doctors, and so therefore, chiropractic doctors, so therefore not only were they, did they have that identity, but anything they did had to be acting at least, arguably as that. So you have that on one hand. You also have what this court, the words they used were that patient care was at the heart of the matter. And I feel like those two things gave us a kind of a broader look at how that case specifically should be resolved. But I would hope this case would be where we really articulate exactly how this test should be worked out. And that the first step for that is the plain text, professional services rendered. And the first place to look is services, the noun of that. Services mean, of course, you're serving someone. In a medical context, patients. So when we look at the complaint, the counterclaim, the unfair and deceptive trade practices counterclaim, let's look for talking about patient care. In Sykes, we have that. We have talking about patient care. We don't have that here.
Well, if the case law talks about on the appellate level here, Court of Appeals as well as Supreme Court, if the case law holds that the exception is supposed to be broadly interpreted, then we don't need to look to the legislative intent as a court system if we're satisfied with the declaration having been made and reiterated that it should be broadly applied. Would you not agree?
Well, broadly applied is going to give us some sort of general perspective, but that's not going to unground us from the language of the statute. And that's why it's very important to work through the words that we do have instead of just kind of walking in blindly and saying it should be broad and saying, is this a professional service rendered? The service here, looping back to that.
Quick question
Yes,
about
Your Honor.
that. What are we to make of or how do we use the opinion of the Attorney General regarding that language about that only those activities which distinguish an individual as a member of a profession, those activities are the only ones protected by the exemption?
Right. I think it goes to, the plain text, I think, really resolves this. But falling through that, if you get to policy considerations, the first step is going to be looking at the AG's opinion, because the AG, Mr. Morgan at the time, was the champion of this law. And so it just makes sense to look to them and see how are they wanting to interpret this exception, since they were the ones that kind of got it on the books. And they use the words strictly enforced or strictly drawn, and that's in response to the legislature's inquiry about, hey, how should we interpret that? That's pretty on the nose.
And just a further follow-up about the impact of the AG's opinion, do you agree with the state's amicus brief that that opinion actually sets out a three-part test? So there's the two-part test of are they a member of the learning profession, are they engaged in professional services? But then in assessing whether or not they're engaged in the delivery of professional services, the AG says we look at whether they're applying the unusual learning that they have as a professional, whether there's a confidential relationship, and then whether what they're doing is not purely commercial. Do you agree that?
Your Honor, I think everything that's said there is completely consistent with what I'm going to lay out here. But I'll say, if I were a law clerk that was about to write this opinion, and I wanted the easiest, most straightforward way to write this and articulate this, which our state needs, because this is, this court kind of really having a chance to clarify this issue, I would go straight to the plain text, those three words, and I think that covers everything that you mentioned, Justice Earls. Professional services rendered. Looping back to the services, here we don't have a complaint that talks about patient services or heart of the matter or anything. We have a complaint that talks about advertising, recruiting, and contracts. Furthermore, it has to be professional services. Every word has to have meaning. Only professionals, and we've touched on this already, only professionals can render professional services. Doctors do doctoring, lawyers do lawyering, plumbers do plumbering, I guess, but they don't do professional services. Whatever they do, it's not professional. And this court has very tightly...
You sure you want to go tell a plumber that?
That's right. Water runs downhill. This court has been very tight about who a professional is. There's lots of folks that we admire, teachers, nurses. They aren't professionals, apparently, for these purposes. And so when we're looking at these services being professional, it has to be done by people who are professionals. I'm not sure how anybody can, not practice law without a license if they're doing professional services and yet they're not a lawyer. Here, who's doing all of the relevant acts? It's a CEO, Mr. McNair. He's not a doctor. It's an administrator, Mr. Whitaker. He's not a doctor. Now, Mr. Freeman set up kind of a straw man about saying, well, we don't have to make everyone in the hospital be a professional. Well, I agree with that. It's going to be a factual inquiry. What was the relevant act here alleged in the complaint? Was it something done by a professional that requires that professional skill, or was it something that wasn't? I thought it was very telling that when we heard Justice Morgan's question about the plumber, we really didn't get an answer to that, did we? Where are the outer bounds of this exception? And how is the hospital defining those? I'm defining them very clearly from, the policy statements from the Attorney General's office, but first and foremost, from the plain text.
Are you contending that this statute is clear and unambiguous and does not require interpretation?
I absolutely agree with that. I think
your view is this language on its face is clear, unambiguous, and can be applied based solely on a textual analysis without more in any case?
It's awful hard to ask a lawyer in any case, but...
I know, I used to do it.
But I would say it's unambiguous. I would say if you asked the people behind me and you gave them some examples, I bet you they'd sort it out real solid between what's professional and what's not.
One thing, and I'm going to change the subject on you, so if you want to get back to it, bear with me. One of the things that, if you read the state's brief, it tends to suggest that 8 or 10 opinions of the Court of Appeals were wrongly decided. It can be read to suggest that this statute, this exception doesn't apply outside the malpractice context. I'm not sure that's what they meant, but they certainly suggested it. Do you contend that all 10 of those decisions were wrongly decided and that this only applies outside the, does not apply outside the malpractice context?
I would say that many of those opinions are called into serious question.
I'm sorry.
And I would say many of those opinions are called into serious question by the plain text, and that.
Are there any of them that you, are there any of them that you think were, that under your view of the statute were correctly decided?
Absolutely. Phillips, for example, a patient cannot bring a UDTP claim based on the doctor's alleged injurious treatment of her. That's on the nose, That's basically malpractice. That's what this exception was meant to hit on. So that one would be fine. I think because there is something of a factual inquiry because of what is the relevant act here, in order to really evaluate, you have to go back in time and develop that record, and so it's unfair to say which ones would.
As the state, and I'll be quiet in a second, I've monopolized too much of your time, but this seems to suggest at least that the Court of Appeals misconstrued this statute from the beginning. You've urged us to pay close attention to it, so that's why I'm questioning you about the state's brief, even though I know you didn't write it and you're free to disclaim it if you want to. We also know that over the course of this 30-year or so series of decisions, the General Assembly has not taken any further action to modify the statute. After all, we are talking about a statute. The ultimate inquiry is the intent of the General Assembly. What are we supposed to make of the General Assembly's inaction in the face of these decisions? Your colleague mentioned that in his brief. If you responded to it, I didn't see it.
Right.
So what is your response?
So you're talking about 10 opinions over 40 years, none of which reached this court, some of which, as I've already identified, I wouldn't even have any problem.
One of them was firm per curiam, wasn't it?
Right. I don't recall. I'd have to look and see.
The Phillips case?
Right. Well, the Phillips case was the one that I said was spot on the nose I'd agree with. So absolutely. So you also are talking again about why were unfair and deceptive trade practice claims enacted in the first place? Because of this great power discrepancy where plaintiffs couldn't get the relief that they needed from the traditional claims of fraud and breach of contract and that sort of thing. They couldn't afford to bring it without having provisions for like attorney's fees and treble damages and that sort of thing. You wanted to create a claim that would give power to some powerless folks in the face of large corporations that are really stacked up on lawyers. So I'm not surprised that a lot of these cases didn't make it further than they did, that they may have gotten settled, we don't know. I wouldn't read much out of the fact that this few cases, the legislature hasn't responded further. Looping back to it being professional services, again, nobody here was a doctor. Mr. McNair, Mr. Whitaker, not doctors. We don't ask that everybody here be a doctor. And this is entirely consistent with Sykes, where you had an entity that was entirely made up of doctors and so therefore was acting through doctors. And so arguably you're able to add that adjective in of professional services. And the final plain text word here, professional services, rendered. What does rendered mean? What's the plain meaning of rendered? It means to make or to cause to happen, not affects, not is integral to. If you all sit down, if this court sits down with people in your chambers and you ask, come up with 5 sentences that use the word rendered. An artist rendered a painting, a judge rendered a decision. Can we substitute affects? Can we substitute is integral? Does it mean the same thing or does it mean anything at all? An artist affects a painting. A judge is integral to a decision? No, rendered means to make or to cause to happen. And the only people who make or cause to happen professional services are professionals. So unless the complaint is talking about professionals at this corporate hospital doing stuff, then it is not within the bounds of the exception.
Let me go back to the esteemed Justice Hudson's question that you didn't fully answer, which I think is going to give us a lot of guidance if you do. And that is based upon your foundation that the learned profession exception should not be broadly applied. Are you then asking us to reverse that line of cases that seems to suggest otherwise? Are you asking us to keep the law where it is and just not extend it to this particular case? Or are you asking for something else?
Well, Your Honor, I probably have unfairly taken the bait too much on policy considerations. Again, the touchstone is always going to be the plain text. The policy considerations about whether or not we say what's professional is broadly construed or narrowly construed. You know, is it setting an arm or is it making a report at a, morbidity ward later? I mean, if this court wants to say that we are going to say what's professional is broadly construed, I don't necessarily agree with that, but that is in no way fatal to my case, because here it is so clearly not professional services rendered by the fact that you have administrators and CEOs doing everything in the complaint that it really doesn't matter.
So you're not asking us to overrule any precedent?
It's certainly not necessary. I think that there are some Court of Appeals opinions that might have to be revisited, but there's nothing of this court.
And is that because the facts of this case are so different because of the fact that there were non-medical agents that were representing the hospital, or is there some other circumstance that you feel makes this matter different from those others?
I think the fact that you have the relevant actors here, the CEO and that mid-level administrator, are certainly not doctors. It makes it easy. You can just stop right there because they're not going to be doing anything professional.
I've just taken a moment and gone back through the complaint to look at the allegations made with regard to fraud and then made with regard to unfair, deceptive trade practices.
Yes, Your Honor.
And they're identical. And we have a jury verdict that says no on the fraud claim. Can you give us the best argument why that's not collateral estoppel?
Absolutely, absolutely. First, procedurally, the fraud claim went all the way to a jury, and we are at a motion for a directed verdict. So we're talking about whether at its inception a claim should be able to push through as opposed to the fraud claim, which made its way all the way to the end. So
I'm talking now,
right, after
we've gotten a verdict from the jury.
Right.
And the exact same allegations were made to support two different claims. You have a jury verdict saying no with regard to that claim as it was characterized as fraud. Why would that not be, why would that jury decision that fraud did not occur also control the outcome of this claim were it to survive here?
Right.
I mean, I just envision it going back to the trial court and your opposing counsel making an argument, well, collateral estoppel, we've already had a jury consider these same facts to say no.
I think the most important thing is they have different elements, and the element I would really zero in on is you have a specific intent element on fraud that you don't have to have in unfair and deceptive trade practices. So a lot of times in these entities, the CEO knows this is going to be true. The administrator is kind of, maybe he suspects it. I mean, you can have deceit and unfair dealing that maybe is hard to pinpoint on the nose of this is specific intent to deceive, where an unfair and deceptive trade practice claim is going to go through and maybe a fraud claim wouldn't. I think it's also important to note that, Hamlet is not a 100% winner on this fraud claim. They wanted $1 million back. The jury split the baby a little bit and awarded them about $450,000. And that's a separate issue that's not before this court about whether that might have been a compromise verdict or not. But if we are going to infer anything about what happened with the fraud, which I think is inappropriate for procedural reasons because of the directed verdict, inappropriate because of the difference in the elements, specifically specific intent, I think you can also just look at the number and see that, okay, there was room for, this jury felt some, if we're going to set the law aside and just go with what was the jury's gut feeling, they were closer to my client's number of 0 on that claim than they were to their number of $1 million.
They precisely answered the question with fraud with the word no.
Well, the jury said on fraud, again, I would just cite back to my example of the specific intent is just a different standard and the procedural is just a different standard. Finally, I'm not going to spend too much more time on this. on the policy considerations, because we've touched on it a number of times. But I would ask, just kind of circling back to Justice Morgan's questions about the plumber. Mr. Freeman has admitted that there's something outside the scope of this exception, something. I'd love to know what it is. He's got a few minutes. I'd love to know what it is, and I'd love to know how he articulates it. Is he going to articulate it based on a bunch of Court of Appeals opinions, which is kind of the only thing he has? And if we're going with the Court of Appeals, by the way, we prevailed at the Court of Appeals, so I would ask this court to affirm. But otherwise, if we're going to set them aside, where's his argument in the plain language? Where's his argument in the legislative history? Where's his argument in anything that tells me, here's where I draw the line? I've articulated a line for this court. Professional services rendered, explained how each of those words means something and therefore doesn't mean something. Where's their line? That's my challenge to them. My other challenge to them, and I'll touch on this briefly as well, is there any jurisdiction where this exception or anything like it has been interpreted nearly this broadly? To my finding, to the amicus brief of the state, to the amicus brief of the advocates for justice, that answer is no. And the hospital is basically saying, well, that's not our jurisdiction. When we look at those, and I admit that's not exactly where I want this court to look first, again, plain text first, but those exceptions, whether they're in black and white in the statutes or whether they're judicially created, sort themselves into two categories. One is basically the exception lines up perfectly with malpractice, or it lines up with things that are not commercial or entrepreneurial, which may just be a different articulation of the same thing. Here, the complaint is not something that could be spun as malpractice. And it certainly is commercial. We're talking about dollars and cents in contracts. So if we have, any informative persuasion from the other jurisdictions, again, it's only going to support our position. In sum, the professional services rendered. I just urge this court to have each of those words have meaning. Professional, the actors here aren't professionals. Services, are we talking about serving patients as we are in psychs? No. And rendered. All these words about affected, integral to, whatnot, they don't mean make. Only doctors, lawyers, professionals make professional services. With that, I will ask that you don't allow this corporation to use this exception meant to protect doctors against a doctor. Let this claim go forward and affirm the Court of Appeals. Thank you.
Thank you. Mr. Freeman, rebuttal.
Thank you, Your Honors. We don't have to resolve these claims on the merits to answer one of your questions. The Court of Appeals, they identify, once broadly speaking, that there are professional services being rendered, then it's not for this particular statute. The legislature created this common law exception. They codified it. This is a co-equal branch of government, and common law, 9 opinions in the Court of Appeals and 8 opinions in the Court of Appeals and 1 here have found this is a broadly applied and not allowed UDTP claims to go forward. They all involve black hat activities. Not that I want to wear one, but in Gaunt we have criminal and defamatory activities. In Phillips we have a doctor lying about whether he's board certified, and I think I discussed Wheelis in detail. They said it was a criminal action with malicious purpose. In Abrams we had a contract. In Zaldivar we had a contract that was a non-compete. We had credentialing issues in Cameron. We had billing issues in the Shelton Duke Hospital case. And so we even have the Busby case, which is one of my personal favorites, where the physician, Dr. Busby, told all the other doctors in the community that the jury had found him guilty of malpractice, and the Court of Appeals said because he didn't want them to treat them. And those jurors were not allowed to sue the doctor when he's trying to say, hey, colleagues, don't give these people treatment. It's just such a broad exception that the case law really, and I think the state's brief really kind of does invite this court to overturn the, honestly, Sykes and the appellate court decisions and say this is a very narrow exception, it maybe only applies to malpractice. Yes, Your Honor.
Quick question for you. In your brief, you indicated that, and I'm reading from page 40, 41 of the brief,
My brief, Your Honor?
plaintiff's new brief, that both parties to the litigation as medical professions are members of a learned profession. Does that mean that the hospital as a whole is a member of the learned profession, including everybody in there regardless of whether they are individually members of the learned profession?
It makes you feel icky to say every single person in the hospital is a member of a learned profession. That's why there's that second part of the Sykes test.
But you don't get to that if you don't pass the first one, right?
Correct, Your Honor. But I think you can look at them together as an inquiry as to whether this legislative exemption applies. Is there a learned profession? If, for example, it's not, you don't only have to go. But you could say, is it a learned profession, and are they doing professional services?
But is it the hospital that
Yes.
you're arguing is a member of the learned profession as a whole? The whole hospital, everybody there?
Yes, Your Honor, and I argue that because it's in the Wheelis case, the Shelton case, which specifically said hospitals are members of a learned profession. And I'm sorry, Your Honor.
Does that then mean that if anybody in the hospital, regardless of whether they are degreed as a learned professional, if they're engaged in something relating to medical services, is going to be exempt? Isn't that sort of...
If I could just have a few seconds to answer, Your Honor, please. But
Run.
I would like to answer your question. So we've said a hospital is a member of a learned profession. Then that's where the common sense comes in with that second part of the test is this rendering professional services, or is this someone, painting lines in a parking lot? And so, respectfully, Your Honor, I stand on my briefs to answer the rest of your questions, and I apologize. Thank you very much, Your Honors.
Thank you both. And thank you so much for traveling to Salisbury, Rowan County for this historic argument. Madam Clerk.
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning in Asheboro, North Carolina. God save the state and this honorable court.